Jeremy Roberts and Jeff Millar. If you go ahead and come up for me. He hates it when I say that. Jeffrey is a contributing author to the forthcoming article, Beat Dead by Divorce, Debunking the Deadbeat, and has been an adjunct instructor for Kaplan teaching both the LSAT and the GRE. Mr. Millar has frequently testified in front of both the Missouri House and Judiciary Committee and Senate Committee on seniors, families, and children in support of a rebuttable presumption among fit, willing, and able parents for equal and approximately equal parenting time. He most recently testified in favor of Senate Bill 14 in 2019 and House Bill 229 in 2019. And then we've got Mr. Jeremy Roberts. Jeremy has put his expertise of shared parenting legislative verbiage to use as both the current AFESP National Legislative Advisor and as a former National Legislative Director of the Fathers' Rights Movement. He led the Missouri team on the successful passage of HB 1550 in 2016 and has helped numerous states craft legislative verbiage since then. He's the Missouri State Team Lead for AFESP and Volunteer of the Month for June 2019. He has provided the leadership needed to unite many organizations for success in Missouri. So we're going to do this a little bit differently. They're going to have a period to talk, and then we're going to once again open it back up for a question and answer for about 10 to 15 minutes. So if you, while they're talking, something clicks, be ready to ask a question. We're probably going to take between 8 and 10 questions. So with that in mind, Mr. Roberts.
Good afternoon, everybody. Boy, how do you follow Bob McEwen? Really? But as Jeff and I were sitting back there, we did recognize what an interesting segue. How we went into basically that, you know, we don't have a Declaration of Independence here, but we do declare that we are all equal, right? I mean, that's ultimately what we're doing here. We are trying to establish and recognize the errors within the current law. No-fault divorce was brought up. It's where these situations land after they've gotten appealed by the Court of Appeals in different states, federal legislation, and where everything lands is really where we are reverse engineering what's currently out there across the country, and we're trying to identify small changes that need to be made. And with the amount of verbiage that's already there in legislation and in statutes federally and in the states, basically we can re-alter the course of how these cases come down and where it lands more on an equal shared parenting front opposed to how we all know the winner-takes-all approach. So to get started, who all here, and it's probably the majority of you, have heard of Title 4D of the Social Security Act? So we have federal legislation, we have state legislation. The federal legislation, just so everybody understands what we're covering here, is something that obviously has to be addressed federally and here in Washington, D.C. We have started last year discussions within the Capitol here with congressmen, senators, to begin that process. We are making headway, but everything federally takes a long time, even though a lot of us also know that at the state level it takes a long time. Understand that our talk today is predominantly on the state level. So just to touch the incentive program, we have federal law, and why that's important for our discussion is the federal law dictates that all states have a rebuttable presumption for financial child support. That's one side of the scale. We can't change that through the states. The states are now bound by that, and that's where our discussion begins, is in the states what is lacking. There is a reason why the language that is going across the country is asking for a rebuttable presumption of equal parenting time. It's to equalize that scale. Right now, there are no protections nationally on any state, except for recently Kentucky's language does have a rebuttable presumption in it. But our discussion today is going to be on how to balance and how to address the state level.
And the reason we need to do that is that federal law only discusses, of course, one of the two things that Bob said people care about, votes and money. The federal law only talks about money and how do we enforce child support. So we've actually taken that same language and said, well, look, if you're going to provide a free, enforcement attorney to get your child support, why are you not also providing resources to get your child custody, and in particular, your equal child custody? So we're going to go through some of those things as to the techniques and we've been using to get that state legislation passed.
Back up a little.
Yeah.
Okay, so this first few slides we're going to go pretty quick through. Let's see what we got. We can go to the next slide already. Again, we're going to attack a basic structure for all states. I brought it up last year at the first conference that we had. This year, we want to reiterate this and begin that discussion again and remind you. First thing, facts, findings, and conclusions of law. Court of Appeals in every state you have to challenge your ruling with facts, findings, and conclusions of law. If you don't have that, what the Court of Appeals says is that the states, they presume that the circuit level already did it, and therefore we're going to assume that their judgment is correct. Facts, findings, and conclusions of law is your lawyer's ability to question the judge specifically, and they have to give a specific answer. So what we need is facts, findings, and conclusions of law in all of your state's determining factors. Because what that does is automatically every single case that goes through the judiciary, it automatically opens every case up to appeal without additional steps that the Court of Appeals come back out of. And what more important thing to address than the determining factors of custody.
And what that means is the court has to literally put in its judgment the facts, findings, and conclusions of law for its reasoning. Those are the things you need to mount a successful appeal.
The second thing, the rebuttable presumption of near equal parenting time. That's important, not joint custody. Some people get those two confused. Joint custody could be one parent has 20% share of the physical custody time, the other parent has 80%. So a lot of times the people that come in opposition will say, we already have joint custody. Yes, we do have joint custody. That's not equal shared parenting time. There are small things, and those are the things that what we focused on for the last 5-6 years that we've been doing things in Missouri and also across the country. Clear and convincing burden of proof. There are three different burdens of proof: clear and convincing, beyond a reasonable doubt, and preponderance of evidence. Allegations could go in there, but those are the three main ones. When you're doing legislation, you want to have clear and convincing. Reason being, not everyone, but a lot of people presume that when a bill gets made, that you're going to file it, and that's where it's going to land. We filed it with this language, and that's it. You need to recognize that the committees, when they move through, have committee substitutes. You want to start with the strongest language and then work backwards. If you go the opposite direction, there's political capital in this process, that if you've taken the time to get a bunch of people behind you and support you and push through your capital and legislative branch, you want to make sure you're getting the biggest bang for your buck. So don't shoot low, shoot high, and then negotiate things down the road. So it also keeps that need and desire within your legislature to follow up if necessary.
And the reason for that, let me just sort of expand on those burdens a little bit to see why it's important. So we've all heard of a criminal case, O.J. Simpson or those. In a criminal case, the government has the burden to show guilt beyond a reasonable doubt. That's the hardest one to show. They've got to show beyond any reasonable doubt this person's guilty. That's in the criminal context. In the civil context, where family law comes into, ironically civil is anything but civil, but where the family law comes into, the burden is not beyond a reasonable doubt. It's what's called the preponderance of evidence. The preponderance of evidence is the other way. It's basically, I hate to sort of say this, but 51%, 49%. If you can convince someone about 51%, then you've won your case. So as we're going to see when it comes to things like domestic violence and whatnot, we don't want to necessarily have a preponderance of the evidence standard because that's too easy to get to. It's only 51%. Floating somewhere in the middle of those two is clear and convincing. And that's important, and these are all buzzwords. Clear and convincing is a buzzword because then the court is going to know, oh, I've got to have something I've got to have something that shows more than just that 51% preponderance. So that's why we always advocate the best we can for clear and convincing standard of proofs.
And lastly, number 4 there is the amendments. Basically, you may have the best language in the world in there, but again, through the committee process, through the legislative process, an amendment can be added on. It could be a simple word that changes an and, a shall to an or. And you skip through that thing, and that literally can change downstream every case significantly. So with that in mind, we want to address that factor. And what we're going to do, and we, as I stated before, Kentucky is the only state that has a current rebuttable presumption. But for the last few years, we've heard things like the best law ever since this was passed, and that this was this end-all be-all piece of legislation. I think a lot of people are fooling themselves. This is something that I commend Kentucky. I think they did a great job up until the point of there was an amendment that was added, and we want to address that.
So here's where it becomes applicable as we get these amendments added by the domestic violence or DV industry. So if we can go to the next slide. Yeah, that's kind of small. Sorry about that. Let's see. Yeah, we can go to the next blow up. There we go, it's a little bigger. So great, I mean, here's what the Kentucky law says. It says, and I'll read it, I underlined it in red, there shall be a presumption rebuttable by a preponderance of evidence, so we wish that were clear and convincing, but rebuttable by a preponderance of evidence that joint custody and equally shared parenting time is in the best interests of the child. Awesome, right? That's great. That's a rebuttable presumption. Way to go. That's exactly everything you've been looking for, right? Absolutely not. And I've seen 5 or 6 of these lowercase national parents organizations come and tout this as the standard for the country, and we don't want that. Why? It has everything in there, doesn't it? Let's go to the next slide. We forgot. Subject to KRS 403.315. What the legislature giveth, the legislature taketh away, in just those little words. So that presumption is completely eviscerated by making it subject to, we can go back one, making it subject to 403.315. So what does 403.315 say? All right, let's hit that. It says, the rebuttable presumption shall not be applicable, next slide. Yeah, if it, and here's the problematic part. If a domestic violence order is being or has been entered against a party by another party or on behalf of a child at issue in the custody hearing, the presumption shall not apply. So what's the point? Not only is what's the point, these organizations are going around touting this as the law that should be copied from state to state to state. Absolutely not. We cannot have this. And it makes me wonder, do these national parent organizations even have attorneys working for them? Because as soon as I saw that, I said, we cannot have that. And I think I tried to highlight it in yellow. We have to deal with DV. And I'll show you how we deal with DV, and I think what I'll suggest is a better approach, the way we try to do it in Missouri. We have to deal with it. It's out there. There are valid cases of DV. Here's the problem I have with Kentucky. I don't even have a problem with if an order has been entered against somebody. But what the heck does it mean if a domestic violence order is being entered? I mean, does that mean someone's filed a petition? Does that mean there's been a judgment? Does that mean there's been a hearing? Does that mean there's been notice? Does that mean that one of the parents just got ticked off and left and said, I'm going to go get an order of protection? We have no idea. But it doesn't matter because that is being entered against someone. You know, someone forming the intent in their mind to say, I'm going to go down to the courthouse and get an order of protection, that is being in the process of being entered. And the problem is, it eviscerates the rebuttable presumption language. So what I want you to take away from this talk, this hearing today, is we need to advocate for stronger, better language, not this Kentucky model, because it completely eviscerates the rebuttable presumption whenever domestic violence is alleged. So how do we deal with it? Let's go to the next slide. So the way we dealt with it in Missouri, and again, I apologize, that's small, back one, yeah, there we go. We have our language that says there shall be a rebuttable presumption that an award of equal or approximately equal parenting time is in the best interest of the child. That's your standard rebuttable language, rebuttable presumption language. We added that it could be rebutted if the parents otherwise agree. Well, that makes sense. If for whatever reason the parents don't want to do equal time, they can do what they want. As a legal matter, that would rebut the presumption. But then along came the dreaded amendment, the DV industry, and they wanted to tack on an amendment to say we also need some type of exclusion for domestic violence cases, which in Missouri we already have in our statute. So we, of course, fought a sort of tooth and nail, but the end result is in red, is it can be rebutted if the parents agree, or if the court finds that a pattern of domestic violence has occurred, as set out in the statute referring to it, defining it.
So if you look in that statute, you'll see two main words are right there in that language. Find, so there has to be a finding, and two, pattern. That's defined already in case law. So again, notice we're not focusing on entire sections. We're even focusing on single words here and there. That's what's going to carry the weight.
Yeah, so why is that important? Why is that important? Because that then gets the attorney to be able to get into, excuse me, what is a pattern of domestic violence? Domestic violence is defined, but a pattern isn't. So let's go to the next slide. I apologize, it's small. I can talk to you after about this. So a pattern lets me now get into Missouri case law to defend against someone trying to rebut the presumption. Is a pattern a single heated argument that lasts all day and all night? Is it a physical fight? Is it two physical fights? Because it has to be a pattern. Do the police have to be called? How many times do the police have to be called? So all of a sudden, I can use these techniques to say and to refute a pattern of domestic violence. I cannot do that in Kentucky, because Kentucky says once is being entered. It's so vague. You can drive a truck through it. So that's how, at least in Missouri, we've tried to handle the domestic violence. Situation is try and pin it to the state's existing statutes, which then allow you to use case law to try and work your way through the domestic violence rebuttal.
Right, we don't need everything in that actual language amendment. It needs to direct to your current statute that every state already has it. So that way you're not giving them too many abilities and too many ways in when we already know that the scale's leaning one way more than the other. So next slide, we're going to speed up a little bit here. Basically, these next two slides are on introducing the legislation. It generally, just so everybody knows, it takes 3 to 4 years on average to pass proper legislation. So if you get something through 1 or 2 years, you almost want to be a little leery if it has any teeth to it, that you may have let something through that may benefit the other side. It's good to challenge your language, go to committees. It's a slow process, but when you get there and you do it the right way, it's a lot better than having to put something through first, in a first or even second year bill, rush it through, and then think, now how am I going to get that out of there? So therefore, you got to take these right-sized bites of the apple and adjust small areas of statute, not everything at once. And also, you want to have backup bills. It could be something that's on I talked about the legislative tree last year. You have basically the trunk, the main issue, the limbs that branch off, and then the leaves, some of these issues that are kind of on the edges. You could have amendments waiting for like halfway through your legislative session that you could enter in and maybe add to something else before the cutoff date for legislation. So always have a backup bill. Next slide. Look for simple words, shall, may. Basically, we want to incorporate and make sure that our language still allows for judicial accountability and judicial discretion. The Senate and the House will write your legislation. If you don't know anyone, if you have an attorney, they can work with your legislators, who then sometimes can get in with the House and with the Senate, and you can have a meeting and help actually draft your legislation. But if you don't know it, don't be afraid. Talk with your legislator. They can get you in touch with research. They can draft your legislation. Next slide, please. So find who you're going to find as a sponsor. Basically, you want to look for committee chairs. If you have one, your own sponsor may or may not be somebody that can help you, but they'll get you in touch with somebody that can, and maybe they have strong relationships within the Capitol. So obviously, you're going to look for your seniors, children's, and families committees, your Judiciary Committee, General Laws Committees. Next slide. The other kind of not a trick, but a way that you can, how do you know what an amendment is going to be brought up to you or to your legislation? You do what's called dual, how do I say it in here?
You're going to file the bill both in the House and in the Senate. And I didn't realize this at first, but it worked out wonderful for us this past year. We filed and had the hearing called up on our Senate bill first that drew out the opposition to it, and they put in all their opposition, so we knew what it was, we knew what their arguments in opposition were.
And then we pulled that bill.
We pulled the bill and then went to the House side.
The other bill working
and we were able to preempt all their arguments.
Next slide. So how to build political capital, things that can help you in the actual Capitol. So obviously what we can all do is local events. A lot more people I notice across Facebook and people that I've talked to regularly. There are more local meet and greets kind of things, maybe monthly meetings with people that you know. Just starts anywhere. Starts at a local coffee house. You want to break up your state, any of the leads or anything like that are here. You want to break that up by your appellate district. The point is, every state has different appellate districts. When you're bringing people in to testify, you can, if you go by your appellate district, it carries more weight with the legislators, because now you're not just saying, or you don't give them the opportunity to kind of deflect what's going on in a specific district. Well, that's just happened in the Eastern District, the Western District, the Southern District. You bring in people, and if you have chapters or if you have branches within your organization, within your local appellate districts, you can bring in the similar stories from all the districts who immediately quash that debate that could happen without it in a committee hearing.
And your appellate court website will have what counties make up what various districts.
Yeah, the maps and all that. Yeah. You want to build your legislative relationships, and the key is positive optics. So if you can do something as simple as getting people together once a month and maybe do that highway cleanup program with an organization. Put something on your, on a vest with your organization and go out and clean up the streets. It's optics is what you want, because all of that carries over when you get the news, when you get interviewed. It all carries over as political capital when you get into the Capitol, talking with legislators. Aren't you those guys I saw on the news that are doing those good things in your local community and the food banks and food drives? And so think outside the box here. Next slide. Obviously, boots on the ground are necessary. You want to get to the Capitol or have somebody in your group that can carry themselves in a professional manner at least once a week, or if you can, during the legislative session. But like once a month, that's not going to be enough, because otherwise you're allowing your legislator, not to say too much responsibility, but the point is they usually have thousands of bills that they're covering. So the point is, you got to keep them on their toes. And a lot of times what you're going to do is they're going to say, what's new? You're going to let them know it's fresh in their mind, they carry things on.
I can't stress enough the in-person contact. You've got to have it. I mean, it's face-to-face, they're going to remember you, but also, what I didn't realize is they're going to be like, oh, you came all the way from, and you're here again. Didn't I just see you last week? Yep, and you'll probably see me again next week. It adds instant credibility to you, to your cause, to what you're saying. Can't stress it enough.
And the floor debates themselves, you want to be able to, again, your legislators they're limited on their knowledge of this. A lot of them haven't gone through it firsthand, so they're relying on you to bring information. Give them a sheet that says pros and cons, basically on specific issues that you know you're going to have opposition that they're going to have on a floor debate. You can preempt that and give them the answers and cite things that they can then, if they're questioned on the floor, they can bring that information forward and challenge a senator or an opposing representative on the floor.
We don't have it here, but we literally did a chart, because they're busy, they got a million things going on. The chart literally said, if they say this, say that, reason. Again, everything underneath. And they go, oh, great, that's all I got to worry about? Yes. And you got everything down there. They don't have the time to sit down with you for an hour or so, but they will look at that later if you keep it simple.
Next slide. So this is something to just be aware of. It's that every state does have lobbyist laws. We have a very important case I believe it's going to federal in Missouri regarding someone that we're kind of waiting to see how that comes out. You are activists on like a citizen activist. Are you technically a lobbyist? And it's a gray area with us. If clearly, I believe what the language is in most of the states, check your states. for what their your ethics area of your House and your Senate. But what most states will say is if you are basically getting paid or you represent an organization. So if you're giving out cards, most likely you could be questioned. But check and talk with your leadership, within each house, and they can also help you with that as well.
You just want to make sure you don't run afoul of any lobbying requirements you may have.
Next slide. So there's kind of a discipline that we all need to have. It's pretty obvious to most people. You want to have a professional appearance, be approachable, not combative. Most important thing is what I noticed we all know them. There are people within this community that sometimes go off the handle. We all know somebody that's done it. You've seen the post. They go. Ultimately, what I've seen the vein is with this a lot of times is think about what you're like whenever something doesn't go your way, or you don't understand, and that's the key thing, something that doesn't go your way. Most of the time, if you just educate yourself and you understand, A, what the process is, B, what your argument's going to be, and you prepare yourself beforehand, it allows you more the ability to listen, open your ears more, and debate when it's needed. I think too many people go into a Capitol or go and talk to people and basically don't prepare the right way. And that's what we want you to focus on here. Prepare yourself so that way you can actually have a conversation. It won't all be done in one meeting. Your job is to expand your network and make yourself approachable, professional, and be very prepared on the information that you will be providing these legislators.
And here's one quick tip that it goes back to something Bob said earlier. I mean, we get it. God, this stuff is gut-wrenching. It's emotional. I'm there because of what may have happened in my particular experience with my kid, and I know you as well. Oftentimes what I do to try and take myself out of that so I can be professional, approachable, all those things, is I can say, gosh, I had a client and what they went through, and then I can almost speak about it as if I'm in the third person. 9 times out of 10, that client's either me or my kid. But it allows me to disassociate a bit of it, so I'm there being professional and not there just sort of, just being all ticked off.
Next slide, please. So this is just a visual. I brought it up last year as well. This is something that kind of at the bottom is a sense of this. It has to do with the political capital. That's the stuff that's actually going to make the change. What that is, that's a sailboat going away from you. It's called a run, the way that it's sailing. Sail on the left and sail on the right. Basically, you've got a left and right with every issue in the legislative body. One's run by public opinion, and the other side is run by basically the functional reform that you want to have happen. You will, and what's on top there is a range. You will have to compromise. That's why you start your language at the highest burden of proof and within those 4 areas that we were talking about. Because then it allows you to negotiate. If you don't do that, your ship's going to go flying, off to the left, off to the right, and you basically are going to be in no position, or the only position is going to be to pull your legislation. We want to help you balance that course. Next slide. Conducting a hearing. Understand, anybody in here, who's been in a hearing? Who's actually testified in your state capitol? Okay, so number 1, how long do you get?
2 minutes. 3 minutes.
About cut it in half. About 3 minutes, that's right. Yeah, anything you got. The other thing is make sure that you guys are if you go there, don't all talk about the same thing. We all have a similar story, but there's specific things that one person might have break those stories down. So take 5 people, basically 15, 20 minutes to tell an entire narrative. Not one person is going to go up there and tell it all. Also make sure your people that are testifying understand that is how we are going to conduct a hearing. So don't dwell and don't focus on just one person because they get nervous, they start rambling, things drag out. Next thing you know, you may have somebody that has something great to say at the end and you're out of time for your hearing. So you want to make sure people understand how to do that with the hearing. You're basically going to get 2 days, if you're lucky, of notice. So make sure for basically I would say the ratio is probably 5 to 1. For about every 5 people I interview, and I interview every single person that comes and testifies for Missouri on our legislation. I will talk to them on the phone for about an hour on average with each person to understand each one of their stories, help them break down their testimony to 3 minutes. And the point is, even if I have a couple stories that are the same and I can get rid of a couple because they're overlapping stories, I may get, let's say, 5 people that I want to come, but then again, because I only have 2 days notice, I only get 2. So you literally have to get about 20 to 30 people for one bill to be able to testify and get them vetted properly to get them down to about the 5 to 10 people that you're going to need to testify.
And you're going to be doing this months in advance. I mean, when you meet with them, talk with them over the phone, vet them, you'll be doing it months in advance so you're prepared, but you're also going to tell them, by the way, I'm only going to get 2 days notice. One really effective, one of the most effective things I've seen is if you can get a variety of geography where people are coming from. We had one guy come to our hearing from the bottom of the state, the Boot Heel. I think he drove, what, 3.5, 4 hours? This guy drove 3.5, 4 hours to give 30 seconds worth of testimony, and they were amazed. Like, wow. And that just shows how passionate, how important this issue is. And I think that's something legislatures key into. You didn't just submit something, you're here in person, face to face for 4 hours for 30 seconds of testimony. Pretty impressive.
Yeah. Next slide, please. So some of the bar tactics, just to touch on these, and you want me to attack them, or you want to attack them? So,
you start, I'll explain why.
Okay. Basically, address you can address what every state has is like they call them a legislative review board, or they have different names, but every state bar has that. Go to their website and look at it. You'll find out who the individuals are in charge of it. But the most important thing with that is bar associations are like unions. They have dues, and therefore the bar association itself cannot take a position on legislation in opposition of shared parenting legislation or anything like it unless they poll their membership. There's been federal legislation on that has just passed down recently. The point is, if someone says I'm from the board of on the legislative review board, an attorney that comes up to the Capitol that testifies against something, the simple question is, did you poll your membership, all of them, to come to your conclusion? The answer will always be no.
If they say they're representing the bar or the board or whatnot, they can do so in their individual capacity, but not, there's a new Supreme Court case, U.S. Supreme Court case that came out a few months ago that said in order to do so, because they're akin to a union, they have to poll each of their members. So that should be a red flag. And yeah, I mean, we get it, we know why, and other than the fantastic and terrific attorneys that are here, and we'll see and hear from more of them tomorrow, that are showing their support for this cause, we know why, and all the bar can really do is not take a stance. They'd love to take a stance against it. We know why. It's money. You know, the more money they can make doing this stuff, and this is why this process is so hard. I'm not very good at marketing, but you know, lawyers are part of the problem. They're not part of the solution. Until we get the money out of the system, then all of a sudden cases that they drag out for 18 months only take 6, then they'll start to be changed. And that's actually something too that you can start to get knowledgeable about for a consumer basis, how you also pay attorneys in terms of let's change the dynamic so we can try and make this process easier, faster. The problem with this process taking so long is because of the machinery we're up against and lawyer fees.
Next slide. Looks like we have a duplicate here. Go 1 or 2 there. Same one. So on to credibility. We're under our last couple, so thanks for hanging in with us. On to credibility. This has to do with notifying the public. Legislative process, this is the irony. So we need to have political capital and talk with people and get everybody excited for all this change, right? But the proper way to do it is you can't expose what you're doing behind the scenes to the public too early, or you create your own opposition. So ironically, you need to have a small internal group that you trust, that you work with, that helps a team, basically. You need to make sure you rely on your team and inform these milestones, inform the public of these milestones after they've occurred. So basically, anytime you go to the Capitol on a hearing or something, just make sure you got obviously you have a phone, but that's when you do your Facebook Lives and things like that. Don't preemptively report things as though it's going to happen. You know, you can say, I believe it's going to, but just keep your credibility. Make yourself more of a reporter on this stuff, opposed to, I think this is going to happen. Because all you're going to do is, even if you're the best person at this, you're just going to undermine your own credibility. And be accurate with those Facebook posts. The other thing is control your narrative. So I would recommend that people that are controlling Facebook pages, you don't want to censor, and I get that. But on legislative things, if you have somebody that, unless they're making a valid point and they're addressing the issue, get rid of those posts. The point is, you need to control your own narrative, keep things positive, keep them going, and discussions and debate is fantastic, but limit the name calling, limit all that stuff. It just doesn't need to happen. So, because you have to remember, eventually, if not already, legislators will be looking and reading all of these posts. So make sure that you are doing things to keep things on the up and up and make your optics look good.
On utilizing your media and controlling the narrative, absolutely control it, but have your news releases, your op-eds, have them ready, just don't pull the trigger on them yet. I say that only because when things happen that are positive, they're going to come at you real quick, so you won't have time to sit down and write an op-ed, you won't have time to sit down and write a press release. Get that all done ahead of time so it's ready to go. I think I've rewritten Missouri's a few times.
And our last slide here is the next one. And it has to do with being, we have another slide, there it is. Yeah, there was a duplicate there. So being preemptive into sessional legislative review. So this is something that people don't think about until after been involved in it for a few years. Any positive change that you make or any negative change that occurs, you have to prepare now when they're out of session for what's going to happen next session. Point is, you have to create a team that also looks backwards behind you. I think some people have seen that. It's a great meme that's on there, basically that has, I'm getting beeped at here. There's a great meme that shows, it's the one that has reform, and there's two guys rolling a carpet. It says reform on the front, and on the back it's rolling up behind them. That's the issue that people don't realize. We could put all the best legislation in the world out there, but then again, if you have somebody coming in a year or two behind you that's chiseling away at what you've already done and you'd let it go, you've missed an opportunity. We only had a small window. So this is something that you have to put everything you have into, create the structure and create the environment for not only reform, but to keep the opposition from coming up behind you and just doing things behind from where you didn't see it coming. So with that, I believe that's everything that we have.